Welcome to online study of law of tort. You know, tort is a civil wrong other than breach of contract or breach of trust, and the remedy is unliquidated damages. So, to constitute a tort, there must be a wrong. What is wrong? Wrong is infringement of somebody's legal right or interference in somebody's legal right is a wrong. So it is a civil wrong. It is a wrong in personam. So it is essential that two conditions must be satisfied to make a person liable under the tort, law of tort. Tritious liability arises when there is two conditions are satisfied. First, there must be an act or omission on the part of the defendant. There must be some act or omission on the part of the defendant. Second, the act or omission should result in a legal damage, that is injuria. That is, when we say legal damage, that is injuria. That is violation of legal right. It may not be actual loss, but it must be that act or omission must violate somebody's legal right. Two conditions. First, act or omission is caused, and that act or omission violates somebody's legal right. Then only it is a tort. A person is liable for his act or omission which violates or interferes in the legal right of somebody. So that means act. Act means what? Intentionally doing something. Omission or omitting to do something which a person is required to do. So that act or omission. So that is act is an act which a person is not expected to do. A person is liable for a tort for his act which is not expected to do under law, or he must have omitted to do something which he was supposed to do. Legal omission. He omits to do something which he is supposed to do. So either it is a positive wrong or an omission which is illegally made. Positive wrong or illegal omission makes a person liable under tort. For example, a commits trespass by entering into the land of another. Thereby, he commits a act, and that act that is entering into the land of another, that violates his legal right and possession. Or a person who publishes a statement defaming another person. Somebody wrongfully detains another person. So he will be that is a positive act. Entering into somebody's land, publishing a defamatory statement, or detaining somebody legally. These are positive acts. So similarly, but suppose a person fails to perform their duty, he can be made liable. For example, a municipal corporation has a park, and there is some poisonous berry trees in that park, and the municipal corporation omitted to take precaution that if a child, to prevent a child to eat that poisonous berry, they give the legal that omission, that illegal that omission, that is, if that causes somebody's death, for that the municipal corporation is liable, which maintains a public park, fails to put proper fencing to keep the children away from poisonous tree. So in this case, that the municipal corporation who is maintaining a park had failed to fence that park to keep the children away from poisonous tree, and the child plucks some poisonous berry and eats it and dies. So in such case, the municipal corporation is liable to pay compensation to the parents of that child. Similarly, If the municipal corporation having control of a clock tower in the heart of the city does not keep it proper repair, and the clock, the falling of the same, if due to falling of that clock, somebody is dead or somebody sustained injury. For that, the municipal corporation is liable because it is an omission to take proper care. In this way, an employer failing to provide a safe system of work, an employer who fails to give a proper the safety to work to his employee is also liable under the law of tort. If there is because omission, act or omission. Act means positive act. Omission means to omit to do something act which a person is not expected to omit. So this is for every tort there must be an act or illegal omission, and that act or illegal omission must interfere or infringe the legal right of somebody. Unless a legal right of somebody is violated, there is no tort. So, wrongful act or wrongful omission must be one recognized by law. Then that wrongful act or wrongful omission must be, if there is a mere moral duty, suppose a person doesn't save a save a child who is about to that is a drowning child who is about to sink or die, falling in a tank, then for that he is not liable. So that's why it is a moral wrong. Law, that means for there must be a law, legal act. Wrongful act must be a legal wrong. It may be noted that wrongful act or wrongful omission must be recognized by law. If that wrongful act or wrongful omission is not recognized by law, then there is no tort. Suppose mere social wrong or moral wrong cannot be make a person liable. Suppose you are X is passing on the road. He found somebody is falling on the, or somebody is lying on the road, sustaining injury due to an accident. He omitted and he went away. So for that, omission is not liable. Because if somebody fails to help a starving man, somebody doesn't help a starving man, or save a drowning child, it is not a tort. It is only a moral wrong. Therefore, no liability can arise under the tort. So you should understand, probably by now you are clear, for every tort there must be an act or omission. That act or omission must interfere, cause legal wrong to somebody. So that is, in order to be successful in an action for tort, so first the plaintiff has to prove there is a legal damage. There has been illegal damage caused to him. What is legal damage? That means it is to be proved there was a wrongful act and an omission causing breach of legal duty. If somebody breaches his legal duty or the violation of legal right vested in the plaintiff, there is the act or omission which violates the legal right of the plaintiff, or which is violation of the legal duty of the defendant. There has been violation of a legal right, the same is actionable. So you should understand, when there is a violation of legal right, that is actionable. This is based on the maxim injuria sine damnum. Injuria means not injury. Injuria means breach of somebody's legal right. Injuria means what? Injuria means infringement of a right conferred by law. Injuria means infringement of a right conferred by law on the plaintiff, or an unauthorized interference in the right of the plaintiff. However trivial may be, it may be a slight interference also with the plaintiff rights. So unless there is a injuria sine damnum, there is no tortious life. No action lies under the law of tort. So damnum means substantial harm. Damnum means harm. It may be monetary harm, it may be harm in comfort, or it may be trivial harm, a small harm. That is money, comfort, health, or the like. Thus, when there has been injury or the violation of legal right, and the same has not been coupled with damnum or harm to the plaintiff can still go, still get a compensation under the law of tort. The leading case in the matter is, what is injuria sine damnum? That is Ashby versus White case. That is the landmark judgment in this regard. So, your answer, injuria sine damnum. That means injuria sine damnum means violation of legal right without causing any harm. Violation of legal right without causing any harm or loss to the plaintiff. So, those which are actionable per se, there might be torts which are actionable per se. There are other types of torts where damage is equal. But when there is a injuria sine damnum, that is actionable even without proof of this actual damage. So, in such case, there is no need to prove that a consequential act the plaintiff has suffered any harm. When there is a injuria sine damnum, plaintiff is not required to prove that actually he has sustained any loss. Only he is required to prove by the act or omission of somebody his legal right was infringed or interfered. In other words, ubi jus ubi remedium. That is where there is a right, there is a remedy. So since law has given him a right, whoever violates his right, and even if that he has not sustained any actual damage, but still is liable, still he can realize compensation from the person who is injuria, that is, who violates his legal right. As we was a leading White case, a leading case explaining the maxim injuria sine damnum, what it says in this case, a voter went to cast his vote. The presiding officer, the returning officer, returning officer did not allow him to register his vote. The person to whom he would have voted, that voter would have voted, he won the election. There was no actual damage to the voter. But in spite of that, the voter filed a suit under the law of tort to get damages. There, and he succeeded. Because though a defense pleaded that no loss was suffered by the refusal because the candidate for whom he wanted to vote won the election, in spite of that, it was held that the defendant was liable. This is Chief Justice Holt. What he observed, if the plaintiff has a right, he must necessarily have a means to vindicate and maintain it. That is, ubi jus ubi remedium. And a remedy, where there is a legal right, there is a remedy. If it is included in the exercise enjoyment of it, and indeed it is vain thing to imagine a right without a remedy. Even if no actual loss is caused, no damage is caused, but still a action lies under the law of tort. In such case, there may be nominal damage. Nominal amount may be paid as damages to the plaintiff. That is exemplary damages of 50,000 rupees was given. Why? Because there was some malice. So, was wrongfully detained by the police so as to prevent him from exercising the right of attending the assembly session. So he was allowed to get, he was ordered that it was ordered that he should get a compensation, that the court directed the state to pay compensated damages of 50,000 to Bhim Singh case. So what is that? Plaintiff, no, though this is the leading case. So when actually there was no loss, no loss in the Ashri versus White case. Actually there was no loss, but because the person to whom would have voted he won the election, in spite of that, that is some amount of damage, a very nominal damage was. But in Bhim Singh case, what? The petitioner on LL.M Jammu and Kashmir Assembly was wrongfully detained by the police while he was going to attend the assembly session. He was not produced before the magistrate within requisite period. As a consequence of that, the member was deprived of the constitutional right to attend the assembly session. There was also violation of fundamental right of the person. Personal liberty guaranteed of that MLA as per Article 21 of the Constitution of India. By the time the petition was decided by the Supreme Court, Bhim Singh had been released. When the matter was decided by the Honorable Supreme Court, by then Bhim Singh had been released from custody. But by way of consequent relief, exemplary damages amounting 50,000 rupees were awarded to him. That was a very big amount at that time. So this is, you should remember these two leading cases. So when you have to answer this, injuria sine damnum. Now it's that you should also know what is damnum sine injuria. Both the maxims must be read together, must be kept in mind while answering this. What is damnum? Damnum means damage, sine means without, injuria means without breach of somebody's legal right. So damnum sine injuria principle is that, this maxim that, though there is damage, there is loss by somebody's act or omission, but that act omission did not violate somebody's legal rights. In such case, it is not a tort. No action lies under the law of tort. There is no tortious liability. What is that? When a person, while he exercising authorized, that is, it means damages which is not coupled with unauthorized interference. There may be damage when there is no unauthorized interference in the plaintiff's lawful right, then it is not a tort. So even damage is, however substantial, that substantial amount there may be loss by the act of another person, unless if that person is justified to do that act as per law, as per the right available to him, so that is not a tort. Then when the exercise of, if somebody while exercising a legal right causes any damage or loss to another, then that is not a tort. The mere fact that a man is injured by another's act, mere fact that a person suffered loss by the act of another person, if that person is authorized to do that act as per law, then that is not a tort. The best, that is, in this context, you should remember some leading cases. That is, first leading case is Gloucester Grammar School case. Gloucester Grammar School case. In this case, the defendant a school set up a rival school to that of the plaintiff. Plaintiff was running a school in a particular locality. The defendant established another school in that locality. Because of better teaching facility, some students of the plaintiff school, they joined in the school of defendant, so that the plaintiff was compelled to reduce his discharge, admission and the school fee from 40 pence to 12 pence per scholar, and thereby sustain loss. So the plaintiff filed a suit under the law of tort to make under tort to get compensation from the defendant who established another school in that locality. Here, the House of Lords held, here there is damnum sine injuria. There is no injuria sine, unless there is injuria sine damnum principle is not applicable here. It is damnum sine injuria. That is, actual, there is loss, but that loss was caused due to exercise of somebody's legal right due to exercise of legal right of the defendant. So, suppose for an example, I have a mill and my neighbor built another mill there, whereby my profit of my mill was reduced. So I cannot realize damages from the from my opponent, from my rival mill owner for my loss. Then this is Blackstone Grammar School case. Second is Mughal Ship Company and MC Gregor Go and Co. It is popular known as Mughal Ship Company case. In Mughal Ship Company case, what happened? A number of steamship companies, some companies, they combined together and drove the plaintiff company out of the tea carrying trade. Some companies, they combine together, they charge less right, so that that is drive another person, this Mughal steamship company, by offering reduced freight. The House of Lords held that the plaintiff had no cause of action because the defendant had by lawful means, by reducing their freight charge, they did not interfere in the legal right of the plaintiff. Then another leading case of India is Ushaben versus Bhagyalakshmi Chitra Mandir. Ushaben versus Bhagyalakshmi Chitra Mandir. In this case, that is called Santoshima case. The plaintiff sued for a permanent injunction against the defendant to restrain them from exhibiting the film named Joy Santoshima. It was contended that the film hurt the religious feeling of the plaintiff. The plaintiff contended this film, that is Joy Santoshima film, hurt its religious feeling. The goddess Saraswati, Lakshmi and Parvati were depicted as jealous to each other and were ridiculed. It was observed that hurt to religious feeling had not been recognized as a legal wrong. So here it was decided it was held that hurt to religious feeling is not a legal wrong of somebody. Moreover, no person has a legal right to enforce his religious views. The person has no legal right to enforce his religious views of another. So it is not a tort. Since there was no violation of legal right, request of injunction was refused. No damage has been claimed, but it has been claimed, injunction has been claimed as on the ground of tort. Then another case is that Action versus Blundell. Action versus Blundell. It is in case of England, what is it? The defendant, by digging a coal pit, intercepted the water which affected the plaintiff's well. Defendant of a coal pit, thereby he intercepted the flow of water to plaintiff's well, which was less than 20 years, and at a distance of about 1 mile from that well. When the coal pit was dug, it was held that the defendant was not liable. The person who owned the surface, so because in this case it was held that the person who holds the surface has also right, may dig thereon and apply all is found to be what? Own purpose. Suppose I have my neighbor has a well, and I dug a well adjacent to the well of my neighbor on my land, and because of digging of that more deep, the water from the well of my neighbor percolated to my well. So there my neighbor cannot file a suit, claim damages from me under law of tort, because by exercise my legal right, if any wrong is caused, if any loss is caused, not wrong, loss is caused to my neighbor, for that I am not liable. So if a exercise of such right, he intercepts or drains off the water collected from underground, springs in the neighbor's well, this inconvenience to the neighbor is not a tortious liability. Another case is Chesmore versus Richard case. This is Chesmore case. You should understand Mughal Steamship Company case. Then that is Blackstone Grammar School case, Ushaben versus Bhagyalakshmi Chitra Mandir case, Action versus Blundell case, and the Chesmore versus Richard. What is the Chesmore versus Richard case? The plaintiff, a mill owner, was for the past 60 years using water for his milk from a stream which was fed by rainfall. From a stream which was fed by rainfall, the plaintiff was getting water to his mill. Percolating through underground strata to the stream, not fixed, but not following in a definite channel. The defendants sunk a well on their land and pumped large quantities of water, so which would otherwise have gone to the plaintiff's stream, thereby causing loss to the plaintiff. For this, defendant were held not liable. It is not a law of tort. So this is very important case. So that is Chesmore versus Richard. Chesmore versus Richard. So this Andhra Pradesh High Court has applied this damnum sine injuria principle when their four defendants tried to ward off the flow of water into their plot from a stream by digging a trench as well as putting up a bond on their land. The fifth defendant also acting independently put a bond on her land to prevent the flow of water to her land. As a result of that, five defendants, the rainwater now flowed to the plaintiff's land, causing damage to them. Somebody put a bond on his land, thereby this water flowed to the land of another. There, this Honorable Andhra Pradesh High Court applied this damnum injuria principle and held that it is not a law of tort. The High Court said that owner of a land or on or near a river has a right to build a fence. The owner of a land by the side of a river has a right to build a fence upon his own ground or to prevent damage to his ground by the overflow of river. Even though a result of the same, the overflowing water is diverted to the neighbor's land, for that the person is not liable because it is a damnum sine injuria. Then Dixon versus Reuters Telegram Company. It is a leading case also here, that is a leading case of UK. What is that? It is another illustration where the defendant was not liable. The defendant, a telegraph company, negligently telegraphed a telegram meant for somebody else to the plaintiff. The telegram contained an order for the shipment of barley from Valparaiso to England. The plaintiff believed that the message was meant for them and shipped the goods, which the sender of the telegram refused to accept. The plaintiff, having suffered a heavy loss, sued the defendant company. It was held that this defendant company was not under any legal duty for delivering the telegram, but he was a legal duty to the person who had sent the telegram. So here the person who shipped the goods should have made inquiry. So defendant company owed a contractual duty only to the sender of the telegram, not to the receiver of the telegram. Since they did not owe a duty to the recipient of the telegram, so here that is not liable. In another case, Vishnu Datta versus Board of Haryana Secondary and Intermediate Education UP, Higher Secondary Education and UP. Vishnu Datta, an intermediate student, was detained for shortage of attendance. His detention was found by the court to be illegal. As a attendance register, the college were not maintained according to the regulation of the board. As a consequence of the detention, he lost 1 year. His action to claim compensation for the loss was not allowed, as the plaintiff's claim did not fall under any of the heads of recognized in common law. And moreover, the statutory provision did not provide for any compensation in the circumstance mentioned. Bradford Corporation versus Pickle case. The House of Lords went a step further and held that even if the harm to the plaintiff has been caused due to malicious act of the defendant, no action lies under the tort unless it falls. There is a breach of legal right of somebody. In this case, the plaintiff had been deriving water from the adjoining land of the defendant, which was at a higher level. The defendant sank a shaft over his own land, which diminished and discolored the water flowing to the land of the plaintiff. So here the plaintiff claimed an injunction to restrain the defendant from sinking the shaft, alleging that the sole purpose of the defendant was to injure The House of Lords held that since the defendant was exercising a lawful right, he could not be made liable even though the act which injured the plaintiff was done maliciously, intentionally, with an evil motive. The plaintiff have no cause unless they can show that they are entitled to the flow of the water. The plaintiff has no cause unless he proves that he has a legal right to get the flow of water. Chessboard research, so here that can be questioned. That was applied in this case. So this is this damnum sine injuria. Another case is Town Area Committee versus Prabhu Dayal. In this case, what this town that is plenty demolished some unauthorized construction of some shops. So in this case, what is that? The plaintiff constructed 16 shops on the old foundation of a building. The said construction was made without giving a notice of intention to erect a building under section 178 of the UP Municipalities Act, and without obtaining necessary sanction required under section 180 of the Act. The defendant demolished this construction. That is, this town area committee demolished this construction. So here, in an action against the defendant to claim compensation for the demolition, the plaintiff alleged that the action of the defendant was illegal, as it was malified. It was held that the defendants were not liable, no injuria, no breach of legal right, because exercising the lawful right, the town area committee demolished those buildings. Similar was the position in Pagdala Nursing Home versus the Commissioner and Special Officer Nellore Municipality. It is Nellore Municipality case. In this case, the plaintiff boss, plaintiff's boss was parked on the road. That was causing obstruction to the traffic. The traffic police removed the boss with the assistance of the municipal employees. It was held that the police officers were justified in their act as the same had been done in discharge of sovereign power of the state. Other examples of damnum sine injuria, that is defamatory statement made on privileged occasion, damage caused under an act of necessity to prevent a greater harm. Suppose prevent a greater harm, suppose somebody's house is burning. Nearby house, the thatched roof of another house was pulled down to save spread of water. So there is no breach of legal rights. So here, similar is the position of when the law considered it to be inexpedient to provide a remedy in law of torts. That is, and it provide elsewhere. The case of public nuisance, causing of death, criminal prosecution. So Jetu Singh versus State of Rajasthan, the respondent applied for the grant of no objection certificate to set up a petrol pump near retail outlet of the petitioner. It was held that the setting up a petrol pump would not be against the interest of general public. It would further be the interest of the general public. There being no violation of legal right. By refusing but not to give no objection certificate, there was no violation of legal. Now, mental element in tortious liability, for a crime there must be mens rea. But so far as tortious liability is concerned, there is no necessity of mental element. It is not. So here, mens rea is a guilty mind is also required in a crime. So therefore, is ordinary punishment is there. But it is not so to make such generalization about liability in tort. The position on the law of tort is, what is that? There may be some evil intent. In many of the branches of law, torts like assault, battery, false imprisonment, deceit, malicious prosecution, conspiracy, this state of mind person is relevant sometimes to ascertain his liability. What will be the amount of liability? So this is sometimes we may compare the conduct of the defendant with that of a reasonable man and make him liable only if his conduct falls below the standard expected to reasonable man. So when the circumstance demands care and person fails to perform the duty to take care, he is liable for the tort of negligence. So that is, there may be also without this fault, that is strict liability principle that we will discuss in the latter, that is Ryland versus Fletcher case. That is what is that? He who keeps a dangerous premises, dangerous cattle, dangerous weapon, let him keep it his own pain. That is Ryland versus Fletcher case. Sometimes, but This is, in nutshell, the difference between injuria sine damnum and damnum sine. So you should remember that for every tort, there must be a injuria sine damnum. When there is a damnum sine injury without breach of legal right or the interfering in the legal right of somebody, there is no tort at all. Thank you.